Our next case is Webster versus Osguthorpe. Good morning. This is also a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal, but we ask that you keep track of your own time, and hopefully we won't use it up before you are finished. And you may begin when you're ready.
Thank you, and good morning, Justices. I would like to reserve 2 minutes for rebuttal. I'll try and keep track of that myself here. I'm Matt Lekulik on behalf of the plaintiff cross-appellant Giorgio Webster, and answering the 2 questions that the court posed to the litigants in its order granting mini oral argument. The Macomb County Circuit Court had discretion to apply the former MCR 24030 to award case evaluation sanctions, and the award of case sanctions was justified in this case. Rather than follow Reitmeyer's abuse of discretion standard or review, the Court of Appeals below instead applied the decision in RAD construction, which erroneously failed to acknowledge and apply the applicable abuse of discretion standard or review set forth in Reitmeyer's binding precedent, and instead applied a de novo standard. The Court of Appeals decision below thereby erroneously substituted its judgment for the sound judgment of the trial court. RAD construction was obliged to follow the rule of law established by Reitmeyer under the rule of stare decisis. If it disagreed with that decision, and there's no indication that it actually did, I think it was just a misreading, it could only indicate that it was only following that precedent because it was required to do so and explain its disagreement with the prior decision. RAD construction's failure to follow this procedure violates the court rules and has created confusion in the state's jurisprudence as indicated by the Court of Appeals decision below. RAD provides literally no analysis of the underlying facts in contrast to the trial court's analysis in our case. There is no evidence of repeated adjournments of a trial date before the January 1st, 2022 effective date of the amendment to MCR 2403 to eliminate case evaluation sanctions. Whereas in our case, during the year following the January 9th, 2021 acceptance rejection of the case evaluation award until the amendment to eliminate case evaluation sanctions.
If you could answer this just to the best of your ability, you might not have the answer to this, but just to the best of your knowledge, is this a one-off case or does this affect a number of cases?
I think that we may be at the outer limit of cases pertaining to this particular amendment of the court rule because it happened some time ago, and I think that the cases where there would be appeals of those decisions have probably run their course. But Reitmeyer and whether an amendment to a court rule applies retroactively or not, I think that that analysis will continue to apply to subsequent court rule amendments.
Thank you.
Counsel, did the trial court, there obviously, I mean, if we're looking at the abuse of discretion standard, and there are reliance interests on both sides, right? I mean, and in this case, it happened to be that your client accepted case eval and they rejected, but it could be the other way, right? But so a party accepting case eval and proceeding to trial, or a party rejecting case eval and proceeding to trial carries, certain risks, and they have certain reliance interests. Did the trial court consider the defendant's reliance interests? I mean, it seems to be focused on your client's reliance interests on the prior rule, right? And if the trial court did not, or at least articulate what those reliance interests are, is it an abuse of discretion to have not considered the defendant's reliance interests as well?
I do believe that the defendant's reliance interests likewise need to be considered to the extent they're put forward. I think that the trial court did so, but there really weren't any. Defendant had plenty of opportunities to settle this case after rejecting the case evaluation award. There were 3 trial dates that occurred before the rule amendment under 24030, before that was eliminated. There were 4 settlement conferences. There was a facilitation before May 6th of 2021. And throughout all of that, defendant did not settle this case, never indicated an intention to settle the case, and accordingly, as in Reitmeyer, it would be afforded a windfall were it not required to pay case evaluation sanctions here. Furthermore, as I pointed out in my briefing at oral argument, defendant abandoned and waived any argument that they relied on the elimination of case evaluation sanctions in formulating their settlement posture when they said, quote, whether plaintiff would have accepted or rejected the case evaluation award, the fact is the same. This case would have gone to trial because the defendants rejected the case evaluation award. And then later he also said, this case would have gone to trial in any event. So I don't think that there really is a reliance interest of the defendant to consider here, whereas we had ample reliance interest, as I partially discussed already. This is a fairly discrete issue, and I think it's been briefed fairly thoroughly. I did want to point out 2 specific quotes from Reitmeyer that I don't know that I had emphasized previously, and I think that they're important for the court's consideration. The first is from page 337, in which the court indicated MCR 1102 provides its own specific rule for the application of new and amended court rules that should take precedence over generalized rules of retrospectivity and prospectivity. And as we know, MCR 1102 was adopted in 1985. Furthermore, at page 345 of the Reitmeyer decision, here, the timing of plaintiff's actions, plaintiff's lack of gamesmanship, and repeated reliance on the rule as it existed at the time he made the pertinent decisions in this case, which is to accept the case evaluation award and to go to trial and participate in settlement. Those are the factors that Reitmeyer directs consideration of in determining whether application of the new rule works in justice.
The trial started, or took place 4 months after we made changes to the rule. Is that correct?
Yes, approximately.
How long after, or tell me the timeline of when we adopted the rule change and when the agreement was rejected?
The rejection of the case evaluation award occurred, I believe, on January 9th of 2021. The change in the rule was approximately a year later on January 1st of 2022, and then the trial occurred approximately 4 months after that.
Okay, so there was time, you were on notice between when we adopted the rule and when trial started.
Yes. And plaintiff, unfortunately, could not control that. Plaintiff wanted to proceed to trial and had gone to court to go to trial three different times before the court rule changed, and couldn't control the trial court's repeated adjournments.
Well, and your client accepted case eval, right?
Yes.
So they weren't at risk
Correct.
of potentially being subject to an adverse verdict for
Correct.
attorney fee purposes, right?
Yes, exactly. And I don't believe it's appropriate for the Court of Appeals below to have considered the amount of the verdict beyond whether the verdict was more favorable to plaintiff than the case evaluation award under the pre-amendment version of 24030 as a basis for finding that application of the new rule did not work an injustice on the plaintiff. The purpose of case evaluation sanctions was to shift the financial burden of trial onto the party who demands a trial by rejecting the proposed case evaluation award. And under that pre-amendment version, there's no consideration of whether the consequence of going to trial ultimately worked to plaintiff's financial benefit, even when the added expense of going to trial is considered, as the Court of Appeals argued. I mean, it's $170,000 in case evaluation sanctions that represents hundreds of hours of work and thousands of dollars in costs expended. And, that's not chicken scratch. That's $170,000 that they should be obliged to pay under the old rule based upon plaintiff's reliance.
So help us think about this. I think, and correct me if I'm wrong, but the way I'm sort of looking at it, there are two sort of relevant events that are there's the accept, reject of case eval, right? And then there's the proceeding to trial, right? Both of those are relevant to either side, whether you accept or reject or what have you, relevant to whether or not you are going to possibly incur attorney's fees in both of those situations, right? So obviously the first one is whether you accept or reject case eval, and the second is whether you proceed to trial. Some of the Court of Appeals opinions seem to suggest that both of those perhaps are equally relevant, right? So that if both case eval, accept, reject, and trial precede this new rule, then sanctions should be awarded. But here you sort of have a straddle case, right, where you've accepted before, but trial preceded, an arguably equally relevant event to this question. How do we sort of deal with those? Like, what would you have the rule be, I guess, in that regard? Like, do both relevant events have to have preceded the event? Does it matter? Obviously, you're saying it doesn't, that they could be split, but what rule would we formulate to say about those events?
Yeah, I don't think that both those events need to have occurred before or after the amendment to the court rule. As you indicated, we have a straddle here, and I think that it's nonetheless appropriate, and the trial court did not abuse its discretion in awarding case evaluation sanctions, notwithstanding that the trial happened several months after. And as I indicated, the Reitmeyer decision pointed out several factors that the court is to look to, including the timing of plaintiff's actions, plaintiff's lack of gamesmanship, and repeated reliance on the rule as it existed at the time. We have all of that here, particularly in addition to the earlier trial dates that plaintiff prepared for and was ready to go to trial on preceding the rule change. There were additional factors that indicate a lack of gamesmanship and an intent to go forward at all times, including the participation in the settlement conference, the in-person settlement conferences, the participation in the facilitation, whereas the defendant never indicated any intent to try and settle this case. They were always going to go to trial, as they indicated at the Court of Appeals argument below. I'd reserve further time for rebuttal unless the court has other argument or questions for me. Thank you.
Thank you.
Good morning. May it please the court. Ronald Letterman on behalf of the defendants, cross appellees. With me at counsel table is trial counsel Zach Lincoln. If I could first indulge the court for a second, I'm breaking in new progressive lenses in my glasses, and my head is spinning in a circle. So if I look at you awkwardly, I apologize. Please don't take it personally.
We share your pain.
Yeah, indeed.
The panel's questions to plaintiff's counsel seem to presuppose that the trial court did have some kind of discretion to consider applying the abrogated court rule. It is our contention, as briefed in our last brief and in response to the Supreme Court's first stated issue, that the trial court did not have that discretion. And the reason it did not have that discretion is that historically, particularly with respect to procedural rules, award of attorney's fees, etc., you utilize the rule that is in effect at the time of the entry of judgment and not anything that occurred before trial. Confusion, I think, has arisen because you've got the cases that are cited by the plaintiff, particularly the Michigan Court of Appeals decision in Reitmeyer, which looked to the standards that were set forth in MCR 1.102, which were intended only to address the proper application of the new 1985 court rules as opposed to the superseded previously existing general court rules before 1985. Nothing in MCR 1.102 gives rise to any intent that it would permit any court.
Counsel, did your client feel there was any risk in the position that they were taking?
I'm sorry, could you repeat it louder,
Sure.
please?
Did your client feel there was any risk in the position that they were taking?
If you're referring to rejecting the case evaluation award,
Yes.
my trial believed that after January 1, 2022, there was no longer a risk because the law changed. And the current state of the law took away that risk by eliminating MCR 2.4030.
Thank you.
Counsel,
Okay.
back to the point that you said about, that the court rule 1.102 only applies to the enactment of the 1985 court rules. Were we wrong then in Ligon's where we said that that the trial court retains discretion to decide?
Respectfully, yes.
Okay, have you asked us to overrule Ligon's, and do we need to do that in order to adopt your position here?
In my supplemental brief where I addressed the first issue, I specifically indicated that Ligon's was erroneous, and Ligon's, all it did was it cited to Rietmeyer, the
Right.
Court of Appeals decision, which applied 1.102. Ligon's didn't say why it was relying on Rietmeyer. Ligon's didn't say why it was ignoring the prior Supreme Court precedent that we discussed in our brief, in particularly Kalamazoo Public Schools and the Balog versus Knight Supreme Court decisions. Those are the decisions that are applicable in binding. And yes, in my brief, I indicated that Ligon's was improperly decided and that the proper resolution is to resort back to Kalamazoo Public Schools and BLOG, which requires the court rule or the procedural statute to specifically state an intent that it be applied retroactively to situations occurring before the change of the rule or the statute.
So your position is anytime this court changes a court rule, which seems to me that would make this case pretty jurisprudentially significant because we do it a lot, that 102 no longer applies? Trial court judges no longer have authority to make a discretionary decision when their straddle case is impacted by both the old rule and the new rule?
If the new court rule or the amended court rule is silent about its applicability, prospective versus retroactive, then yes, there is no discretion and it is to be applied retroactively. My position, if you follow the Kalamazoo Public Schools and the B-Law cases, is that the Supreme Court must specify when it amends that court rule whether or not it will not be applied retroactively.
It seems like we did specify in 102, though. We specified that trial courts can, that obviously the court can look at the facts and decide if there's an injustice or not.
Respectfully not, because 1.102 only applies on its face to the rehaul of the 1985 court rules. And it's erroneous to look to that as a source of authority for decisions in the future, based upon amendments in the future. I say that it's incumbent upon the Supreme Court to amend 1.102 to indicate that it applies not only to the rehaul of the 1985 court rules, but to the amendment of any court rule.
Isn't the Kalamazoo case about how we interpret statutes and not court rules?
I'm sorry?
Isn't the Kalamazoo case more of an analysis of statutes as opposed to court rules?
The Kalamazoo case was a statute, and the Kalamazoo case, along with the Ligon's case, indicated that you construe and apply court rules in the same manner as you do statutes.
Can you give me an example of a current court rule that includes a language that says it about retroactivity or prospectivity?
I cannot.
Yeah, I'm struggling to see one. I mean, it occurs in statutes,
It occurs in statutes.
but I'm
Instead-
not sure of a court rule that's where we are enacting a court rule. Now, sometimes we have effective dates, right?
But so what? I mean, the effective date should say it's effective to all cases or all judgments that are entered on or after this date.
Right.
That's what would be required.
But, so we've left 1.102 in error? We've left that as part of the court rules now 30-some years later?
If you want 1.102 to apply to any new court rule after 1985, then it should be amended. In fact, it need be amended, because it doesn't say that.
Okay.
And it's erroneous to construe it as such, because that construction is contrary to the plain language of the court rule.
Okay, can I shift gears a bit to the reliance interests, your client's reliance interests and weighing risks? You state that your client relied on the elimination of case evaluation sanctions in weighing their liability exposure and formulating their pretrial and trial settlement posture. Can you be a little, I'm struggling to understand, like, can you be more specific of what exactly, how you relied on, how your client relied on?
I could tell you in a general sense without waiving attorney-client.
Oh, sure, I'm not talking
and
about
work
that, but
product
explain
privilege.
to me how the elimination of the rule affected your clients.
My client thought that unless there was an opportunity to settle at a point that it found to be acceptable, then it would try the case without the added liability of $170,000 of the plaintiff's attorney's fees.
Okay, so help me understand, so for 12 months, maybe 13, somewhere in there, your client was under the risk of sanction, right? If you, including during that time period, proceeding to a trial date 3 times and facilitations and that. So there's 13 months where you're subject to that risk, which my understanding, correct me if I'm wrong, would suggest that you bore a risk under the old rule that was eliminated when sub O was eliminated, right? So you had 12 months under that risk, and then you had 4 months where you didn't have a risk.
Right, for the first 12 months, we understood that risk. The case did not settle. Then, January 1, 2022 came around, eliminated that risk, and we understood for the next 4 months until trial started that we would no longer bear that risk. And that is something that we need not consider when assessing our total exposure.
Okay, so let's, assuming we disagree with your first point and that it in fact is an abuse of discretion of the trial court, given how you've articulated the risk that you have, and obviously plaintiff was subject to a risk as well of accepting case eval and proceeding to trial and accepting case eval, right? What is your argument of how the trial court abused its discretion? If there are risks on both sides and the trial court says, I'm landing on this one.
The trial court only considered what it perceived to be the plaintiff's risk. It did not at all consider the defendant's risk. That's number one. And I think that's a point that you raised in questioning plaintiff's counsel. Number two, the trial...
Based on the written opinion, based on the record, right? What was stated on the record.
I'm sorry?
I said based on what was stated on the record. You're saying there's no record evidence that he considered the defendant's risk.
That's correct. There was a written decision.
Right.
And the written decision only in one sentence articulated the plaintiff's risk. Nothing else, nothing about the defendant's risk. And in that one sentence, it misstated, it erroneously stated that the plaintiff had a risk. And it said that the plaintiff took the risk by agreeing to go to trial. That's the exact words that the trial court used in its written opinion. And it's wrong. The plaintiff did not take a risk and decide to go to trial. The plaintiff accepted the case evaluation award, was forced to go to trial because the defendants rejected the case evaluation award, and the plaintiff had no risk at that time thereafter. And that's what we stated in our oral arguments to the Court of Appeals, and the plaintiff is trying to turn that around to saying that we abandoned our argument or something. And
What about the fact that there were multiple trial dates set, and that the trial basically got bumped because of things that I think had nothing to do with you all? So the case was ready to go to trial before the change in the rule. Does that matter?
No,
Why not?
because the fact that there might be a different result had the case been tried earlier is not part of the analysis.
But it certainly goes to the risk analysis you're talking about.
Not for the plaintiff, because the plaintiff accepted case evaluation.
So we're not, so you're saying the trial court didn't examine your risk, but it seems like you're saying we can't consider the plaintiff's risk.
No, I'm saying that not only did the trial court not examine our risk, but it misstated what the plaintiff's risk was. I'm not saying that you disregard any potential risk. I'm saying that the trial court has to state what the risk is accurately. And it did not, because it said that the plaintiff assumed the risk by deciding to go to trial. And again, that's the exact language that the trial court used in its written decision.
Well, could it, I mean, I guess I understand having accepted case eval that the plaintiff was not at risk of incurring attorney fees. But in the year after acceptance and proceeding to 3 trial dates and facilitations in that, did plaintiff incur a risk of proceeding to trial rather than accepting settlement prior to trial?
There was no risk. The plaintiff had to go to trial or dismiss the lawsuit, one of the two, and we know he was not going to dismiss the
So
lawsuit.
because there was no possibility of settlement?
No, I'm saying that
I mean, because if there was in those prior, in that year, plaintiff is running the risk of, if I don't take this settlement and I go to trial, I could get a no cause. But are you saying that there was no settlement potential in that year, which then would seem to cut against you saying that you had,
well,
that your
I
client was at
cannot,
risk?
Unfortunately, I don't think I'm allowed to disclose.
No, I'm not talking
Are-
about specifics about settlement discussions. Obviously, we wouldn't ask you to do that, but I'm trying to understand, you're saying plaintiff had no risk. I understand there was no risk, having accepted case eval, of being subject to having to pay your attorney fees if you got a no cause, right? But there is risk in still proceeding to trial rather than accepting a settlement, unless there was no risk of, there was no opportunity for settlement.
The risk, as it turned out, that you're articulating, I think if I understand correctly, you're articulating the costs and attorney's fees to prepare for trial, and,
No,
or not.
It's you're risking a settlement versus a potential no cause, right? I mean, that's the risk of proceeding to trial. You could get something, even if it's, $14, as opposed to a no cause. So there's some risk in not accepting settlement and proceeding to trial. Plaintiff always was under that risk, regardless of having accepted case eval.
Right, and the plaintiff assumed that risk from day one.
Sure.
That was a risk that he was going to get no caused. The defense always had a risk that it would be subject to a money judgment.
Right, so there's risks on both sides, and if the trial court exercises its discretion in saying which rule or whether or not the sanctions still apply, how do we say that the trial court abused its discretion such that an appellate court can substitute its assessment for that of the trial court?
Well, if you're using an exercise of discretion standard of review, the first thing you've got to do is determine how the trial court balanced the defendant's risk. It did not.
Okay,
It remained silent. It totally ignored it.
okay.
The defendant had the added risk of case evaluation sanctions, which were eliminated 4 months before the trial. The plaintiff did not have that added risk. So under your rationale, both sides would have had a risk of an adverse verdict and a judgment upon the adverse verdict. The defendant had the added risk at one point of case evaluation sanctions, here $170,000. That went away 4 months before trial. And the defendant had every right to rely upon the existing state of the law at that point in determining its settlement posture. Settlement postures change. They may be something on day one, they may be something at the close of discovery, they might be something else at case evaluation, they might be something else at the beginning of trial, after directed verdict is denied, etc. It's
Thank you. Your time is up, is that?
Yep.
Thank you very much.
already?
I know, goes
So
fast.
fun.
Thank you.
You have 3 minutes.
Just a couple brief
Counsel,
points.
how do you respond to this contention of risk that's been going back and forth? That ultimately the defendant, at a certain point, you know, into this process, realized that this was no longer a risk. So ultimately proceeded, you know, according to their plan, based on the fact that they looked at it and said, well, wait a minute, this risk is now eviscerated or evaporated, so we can move forward. How do we just get into this assumption of risk, who had it, when it developed, and how to basically acknowledge that?
Yes, Justice Bernstein. Certainly, defendants contending that there was no longer any risk of case evaluations as of the rule change on January 1st of 2022 was quite ill-advised, absent a ruling from the trial court whether it would apply 24030 should plaintiff prevail at trial, because Reitmeyer was a published Court of Appeals decision that's on the books that addresses this exact scenario. MCR 1102, which Reitmeyer applied, was a binding court rule at that time. And under that analysis, as we've gone through, the plaintiff and the defendants relied heavily on the court rule as it existed prior to the amendment in plaintiff accepting and defendant rejecting the evaluation and going to trial dates, going to settlement conferences, and throughout defendant never making a meaningful or any settlement offer that I'm aware of, and there's none reflected in the record. So I don't think that was a reasonable position for defendant to have taken with the court rule change. With regard to the argument about the older Supreme Court cases addressing retroactive application of amended statutes, I agree. Those deal with statutes, and court rules are a different creature. As I indicated, and as I cited and quoted from Reitmeyer, which was authority that the court had to follow at the time, MCR 1102 provides its own specific rule for the application of new and amended court rules that should take precedence over the generalized rule of retrospectivity and prospectivity. It's Reitmeyer at 337. I'm not sure about the language that Brother Counsel was referring to from the trial court's decision about how plaintiff accepted the risk. I quoted language from page 8 of that opinion in order, which is appendix page 198 in my briefing, which says, and I believe this is the conclusory language, significantly this matter was subject to case evaluation more than 1 year before 403 was amended. The parties subsequently engaged in several settlement conferences and facilitation sessions and had 3 trial dates before 2403 was amended. Plaintiff's decisions to proceed to trial were made in reliance on MCR 24030 while it was still in effect. Accordingly, justice favors application of the pre-amendment version of 2403 here. I don't see how that was an abuse of discretion.
Thank you. Thank you both. The case will be submitted.
Thank you.